Welcome, everyone, to another episode of Spilling Tea. Good morning, all. I am your host, Tiffany Daniels. So, we're going to go over something cringeworthy today. So, just to start off, we are going back to that wonderful world of those torturers of children, kids, and adults with disabilities, the JRC. And folks, it looks like I have a new opponent. So, we are looking at a brief by the new Civil Liberties Alliance. And it is the NCLA brief asks the DC Circuit to stop the FDA's improper attempt to regulate the practice of medicine. This was done back on November the 24th, 2020. Expect a lot of anger to come out of me this morning, folks. Now, before we get started, just a few heads up. As always, folks, if you want to read this stupidity for yourself, you will find the link to this that we are going to read through this morning in the description box, accompanied, as always, with the video that kicked off this entire barrage of videos from me about the JRC, and as well as to shut down the Judge Rotenberg Center petition. If you haven't already signed it, please do. Also, heads up, if you have young ones, we do want to let you know that when we talk about the JRC, you will hear vivid descriptions of, and sometimes actually see actual footage of, people with disabilities being tortured. So please use your headphones. I also apologize in advance if I mangle horribly, as it is 5:25 a.m. in the morning, any words or stumble over my words. It's very, very early. So without further ado, let's go ahead and read this brief. So this is the Judge Rotenberg Educational Center, Inc. versus the U.S. Food and Drug Administration, et al., Louis Aponte, et al., U.S. Food and Drug Administration, et al. Now, folks, this is something that came not long after the 2019 document that we read for the ongoing countersuit in regards to the bans on the GEDs, or painful skin shock devices. Because God knows we can't have a world where people with disabilities aren't tortured for existing, right? Okay. Now that that's out of the way, let's read this idiocy. Okay, like we said, Washington, D.C., November the 24th, 2020, Globe Newswire. The new Civil Liberties Alliance, a nonpartisan, nonprofit civil rights group. Civil rights group? Okay, I'm going to stop right there. Civil rights. Civil rights? What about people with disabilities? Civil rights to exist without being tortured. What about that? Just saying. Filed an amicus brief in the U.S. Court of Appeals for the District of Columbia Circuit, supporting a challenge to a final rule issued by the Food and Drug Administration, FDA. The rule bans electric stimulation devices for aversion therapy. As they should, all aversion therapy should be banned. Currently in use in only one treatment facility in the United States, the Judge Rotenberg Educational Center in Canton, Massachusetts. The NCLA argues that the statute on which the FDA relies does not provide FDA the rulemaking authority it seeks to exercise. Really? Really? So the organization that the government has created to regulate medicine as well as everything else doesn't have the authority to issue a ban? Really, Karen? Congress adopted the statute to permit the FDA to move swiftly to prevent manufacturers from continuing to distribute fraudulent or hazardous medical devices commercially during the time it would take for the FDA to prevail in a court proceeding. That rationale is inapplicable when, as here, no manufacturer is seeking to distribute the devices targeted by the FDA commercially. Um, Here's where you're wrong, Karen. They have absolute regulation, including devices used in hospitals and care centers, including for the elderly and the disabled. The FDA is within its right to protect vulnerable citizens from dangerous medicine, whether it is done widespread and commercially or not. If they did not ban these devices, there are a lot of schools out there that more than likely would eventually took up the device. So you can take your argument and you know where to shove it. But then again, I guess the NCLA doesn't believe that we disabled people deserve to be protected. Right? Right? Because we don't matter. Right? Moving forward. The center's professional staff seeks only to continue the use the devices it manufactured many years ago to deter self-injurious or aggressive behavior in its own patients. I'm going to stop you right there. Since when, in the name of God, is it positively logical and even good to stop self-injurious or aggressive behavior by causing more harm? How does that make any coherent sense to anyone? Anyone? Here's the facts. Ask the common neurotypical if causing harm to them is going to stop their aggressive behavior, or is it going to increase it? Because I'm going to tell you that 9 times out of 10, it's going to increase it. It defeats its own purpose. It is also said numerous times in numerous studies, both by, frankly enough, the JRC itself and outside sources, that these skin shocks do not, for a long period of time, stop those self-injurious behaviors. In fact, it has been stated that the moment that the person is no longer on the devices, the behavior continues. Isn't the whole idea of treatment supposed to be that you take care of the problem and those behaviors do not rise up again? Isn't that the point? Whatever happened to do no harm? Oh, right. That's just for normal people, right? Under those circumstances, the sole enforcement measure available to FDA is a lawsuit seeking an injunction and seizure of devices, a course of action that would at least have provided the petitioners the hearing rights they were denied in the rulemaking proceeding. Really? Really? Because on this very channel, we have footage from those hearings where the parents and even the professionals from the JRC had their moment to talk and present their case. We have seen several videos of that. And now you're going to tell me, well, they weren't heard. Really? See, just because NCLA, the verdict on the devices wasn't what you, JRC, and all the monsters like you didn't get what you want, doesn't mean the other side wasn't heard. Take several seats. You don't get to torture kids with disabilities just because they don't behave in a manner that you like. Moving on. For decades, Massachusetts courts have deemed the center's aversion therapy is both safe and effective for hundreds of patients. Okay, let's roll back. There was a point in time where there was a lot of questionable medical practices that were deemed safe and effective that was turned out to be complete nonsense. Just a few. leeching patients. Okay? Leeching patients, bleeding out patients, all of that was considered standard medical practice in the Middle Ages that was both safe and effective. When in reality, it caused massive harm, infection, and death. So, according to your logic, these things should still be in practice because the doctors of the time, who saw hundreds of thousands of patients, depending on where you are in the world, it was in use, and they said they were perfectly safe and effective. They're not safe and effective when a boy is screaming, crying for help. Okay? That's torture. And also, NCLA, tell me, if these devices were being used in interrogations on war criminals, would you be so willing to call them safe and effective then? I don't think you will. But because it's used against people with disabilities that the media and the world has maligned for millennia, well, then it's just perfectly fine, isn't it? It's what we deserve, after all, for daring to exist. Okay, moving on. Thus, fearing a federal court would reject its unreasonable and substantial risk claim. There is unreasonable and substantial risk. Did you not see pictures of freaking skin burns? There is one girl who has lost all sensation in certain parts of her limbs. There is untold psychological damage that we're only beginning to see the repercussions of. But go off, Karen. FDA opted to pursue a rulemaking proceeding, as they should. We should expect to get some kind of protection. But not according to these people. We don't deserve it because we're horrible people. We're a danger to ourselves and others. A dude was shocked over 31 times begging for help because he refused to remove his coat. Really? By proceeding in this fashion for only the third time in its history, FDA was able to prevent the center from cross-examining the FDA's witnesses and effectively responding to the assertions the FDA made to support its finding. Okay, first off, cross-examining the witnesses. So y'all didn't have time to speak at all? I didn't see the panel cross-examining the JRC witnesses. They were allowed to speak and have their time. So why do you have the right to do what the FDA did not do to their experts? It was supposed to be open where everyone could speak and leave their comments, and they did, unhampered, both sides. All right, Karen? FDA seeks to prevent the center from continuing to use its ESDs. Yes! The FDA's rule will allow substantially similar devices to continue being used to treat other medical conditions, such as for smoking cessation. Actually, Karen, if you read that 126-page document, it has not been used for smoke cessation in civilized medical care in over 30 years. Try doing your research. The NCLA is deeply concerned that the FDA has violated the petitioner's procedural rights and has arrogated itself powers not delegated to it by Congress. Oh, you are so full of shit. They have every right. If a medical device is proven to cause substantial and risk, unreasonable risk, they are completely within their rights. In fact, you just made a point against yourself. The fact that it is, if you are right, being used outside the facility to make people stop smoking. you're going to torture them to stop smoking now. Okay, remember when I said this doesn't just affect us folks? Well, apparently the NCLA believes that if you're a smoker, you should also go through this torture too. The NCLA is asking the court to vacate the rule. The NCLA released the following statement. Not only is the FDA acting in bad faith, but interfering with the practice of medicine by attempting to dictate how the center must treat its patients. It's called the law. You know, there are laws that are there in regards to medical care to protect patients. Okay? In your world, there would be no laws at all, and doctors could get away with whatever they wanted, regardless of whether it was dangerous to the patient or not, because that's how the doctors deemed it was best to treat them. Okay? There are laws that regulate medical care for a reason. Okay? That includes the FDA having the right to ban harmful devices that are being used to torture U.S. citizens whose only crime was being born with or acquiring later in life a disability. That's it. So they deserve worse treatment than war criminals for things that they have no control over, who've done nothing wrong? Wow. The law permits hearingless bans would violate due process rights and thus would be simply unconstitutional. You've got some balls. I'll tell you this, rich samp. I'll tell you this. It is not unconstitutional when the FDA does its job. As far as due process, both sides were heard without cross-examination on either side. Both were allowed to speak freely. The fact that the FDA saw what this center was doing as dangerous means they saw the facts, they saw the pictures, they saw the medical records. We do not live in a world where medicine is not regulated, thank God. Because if we lived in that world, nobody would ever want to go to a hospital again. I can guarantee you that. There might be a doctor out there who may have their own issues who decides that someone needs surgery who came in with a broken leg and they decide to do open heart surgery on them while they're there. That's why there are laws in regards to medical practice. And guess what? The government has every right to persecute doctors that violate those laws, and the FDA has every right to act in the best interests of those who are being tortured for simply existing. You don't get to torture us just because we don't conform to your normal, because we do not comply, because we do not obey. You don't do that to any other person in this world and consider it right. But for some reason, if it's in the name of treatment, you, NCLA, think that it's okay and right and that people like me don't deserve protection. Well, I just have one thing to say to you. All right, I told you there was going to be a bit of a rant, folks. So, again, I'm going to include this travesty of a brief in the description box, as well as all the other things I mentioned at the beginning of this video. I need to cool down now, so I'm going to go ahead and close out of here. As always, folks, we don't get very many views on this channel. The few that we do get do tend to get removed from time to time. So don't forget to hit that like button. Hit subscribe. Don't forget to hit the comments. Also, folks, YouTube is once again, I think they're doing one of their purges or something because All of a sudden, I'm losing subscribers again, so please check to see if you're still subscribed to this channel. I do appreciate your time this morning, and as always, folks, we here at Spilling Tea hope you have a good one. Bye-bye.